historically, the present scandals and crises, starting with Julian Assange and Bradley Manning and now Mr. Snowden, all reflect a curious sense of freedom of the press, of First Amendment freedoms and Fourth Amendment freedoms in America under the Constitution, which meant that there was never, oddly enough, an Official Secrets Act in America. That didn't happen. There never was cause for it. You could prosecute people under espionage or treason or something else, but there was no Official Secrets Act. Part of the thinking there was that you bias your laws in favor of free expression rather than biasing them for national security, with the hope that you'll retain some freedom of the press in the end. I mean, they've been after Assange for over 2.5 years. They've not found a single law for which to prosecute him. Bradley Manning is in jail, and the charges have by no means been proven in court yet. So, and they may not be, according to a lot of constitutional lawyers. So it's a risky strategy of the government to try and prosecute on behalf of a law that doesn't really exist. With the present case, they may well do something else. We don't know what will happen in the Snowden case. It's still developing. But these will promise to be the biggest disclosures for transparency and accountability in the history of the United States. I mean, they're very powerful, large disclosures, which elicit a lot of public interest, both pro and con, but they'll certainly elicit the interest of concern over the degree of spying and intrusive surveillance that now is commonplace in the United States. In the case of Assange, with very important connections to the Bradley Manning case, is to open a secret grand jury meeting in Virginia, a federal grand jury, which will examine the evidence against both Assange and Bradley Manning. They're both connected. One, in theory, got the information from the other, which would affect, of course, the NSA whistleblower very importantly, should a certain result come out of it. But the effect is to hear enormous amounts of evidence, witness testimony, documents. The FBI has 42,000 documents, apparently, in this case. But the defense has not seen any of them. And I think it's important to say that so far, these have not been hostile, in a sense, to the idea of disclosure, because so many more whistleblowers seem to be coming forward. In other words, people aren't intimidated by these quite draconian processes. It certainly hasn't stopped Mr. Snowden from coming forward with disclosures at least as serious and much more interesting and more explosive in many ways than the first two. But in any event, we've just the beginning of a significant process which is entirely unique. We've never seen anything like it in the United States before. Investigative journalists are particularly concerned and following intently the results of these three cases, because how the disposition of the court is decided will affect what we do quite profoundly, perhaps not as dramatically as some of these big cases, but quite powerfully. Because if whistleblowers, who often for the best of reasons give information they feel is of critical importance to the public, about corruption, about violence, about human rights abuses, about important things that the public needs to know about in order to stop, if nothing else. If those are stopped, if these disclosures are stopped, then people will be quite frightened to come forward. And the effect on investigative reporting, which is a key element in keeping a citizenry informed in a democracy, will be severely compromised.